Any mention?
Please, Lordships. Lordship, I beg to mention item 8, Lordship. Lordship, this is part heard matter. Lordship, we've already argued on the facts, Lordship. Just on law points, we have to add, Lordship. We pray for 1 week's time, Lordship.
Yes, Lordship. Let it be 2 weeks, Lordship. Otherwise, I was ready today.
Highly obliged.
Please, Lordship. I'd like to mention item number 16, Lordship. Pray that 2 weeks' time will be given, Lordship, for hearing. 2 weeks. Obliged.
May I please, Your Lordship? I beg to mention item number 17, my lords. No, my lord. Not my lord. Lordship, I beg to mention item number 9. I'm praying for 2 weeks' time. 9. Yes, my lord. Part heard, my lord.
Yes, Lordship.
My lord.
Please, Your Lordship. Lordship, I beg to mention item number 19th. Two weeks, Your Lordship.
May I please, Lordship? I beg to mention item number 11 and 12, Your Lordship. It's a connected matter. Yes, Your Lordship. Part heard, Your Lordship. This matter.
No, Lordship.
No, Your Lordship. It's just part heard, Your Lordship. Oh, 2 weeks, Lordship. Kindly. Obliged, Lordship.
May I please, Lordship? I beg to mention item number 26. This matter may come up after 3 weeks, Lordship.
On the list, item number 1.
lord, in this matter, the respondent was supposed to bring instruction. The respondent was supposed to bring instruction with regard to the missing page. This is a part heard, yes, your lordship. This is a part heard matter.
Madam, Angela is in this case.
313. In the from the records, the 313 page was missing. One page was missing. Paper from the paper book. Then your lordship has asked the respondent to verify.
Your lordship, as on the last week, your lordship, there were 2313 that was being recorded. So your lordship had asked us to verify from the records, and we've done that. Your lordship, it's a continuation, your lordship.
My lord, may come to page number 132. From the paper book. Then last para, question number 17, my lord. Then after that, there is the page is missing. Then after 17, it's directly start from question number 26.
May I please, your lordship? Lordship, on the last occasion we were... Lordship, we were also directed to ascertain from the records, my lord, if what has been submitted by the counsel for the appellant is in fact as it was. And lordship, on records also, from question number 17 it jumped to question number 26, my lord. So something is missing from the records itself, lordship. Exactly, my lord, it's just a question.
Do you have any instruction on the 2000 there, whether that is originally like that or?
Lordship, this is 2018. I think the prosecutor also will have changed, but nevertheless we'll write to the prosecutor's office, lordship. We'll try just to ascertain.
One thing is here, certain pages are.
Yes, pages are missing, my lord.
Now, how do we locate it if it's not there?
Exactly, lordship, because it's also a 2018 matter, my lord.
Trial, we cannot ignore.
Lordship.
And when the solution?
The records speak for themselves, my lord. It's not there. It's not there.
But then, one thing is here, that some pages are missing.
Definitely, lordship. It won't end with a question. There will be an answer to the question.
Which way we resolve?
Judges have changed. Prosecutors have changed, my lord.
Trial court, which is responsible for this. The record has not been kept.
My lord, what is the practice from the defense side is that after every stage of evidence and even 313, my lord, they always procure a certified copy, my lord.
They may not always procure,
but most of the time they do,
that
my
of
lord.
course they can say.
Yes.
If they have it in their record.
If they were the counsels that time also, my lord, I'm not sure.
Even the trial court
Lordship.
lawyer who was there, then you see, it is normally after the end of the trial, certified copies are obtained, and then argument. If any one of you, can you verify from the counsel the trial court, whether he has,
We were not the counsel at time, Your Lordship.
then he must be knowing who were there, isn't it?
We do not know, madam.
It'll be on record. It'll be on record. Yes.
Which way you resolve it?
You also give as per the records, right? This one is that's okay. I don't think so.
One is E-Ninja was declared.
Lordship.
You don't know her. You have any personal acquaintance with her? No.
E. Rinja might be the present counsel for POXO court, Lordship. Yes. Do we have Xerox of the documents? And at the time of pronouncement of judgment, my lord, it was Mr. Y.P. Chaudhary.
98, Your Lordship. Internal page 18, Your Lordship, of the judgment. PW1 Shri Sahadat Ali is the one who had lodged the FIR, but he had not witnessed the incident. On the day of incident, he was at home at so-and-so and had received information over phone from one village about the incident and the involvement of the accused person. What can be gathered from his statement is that on 12/7/2016, when Bodil Sheikh went to Khalitan market at around 8 a.m., he was attacked by Khalil Sheikh Abdul Khalil. So and so, and somehow Bodil Sheikh managed to escape to his relative house Islam Hague, which is nearby the Khalitan market, but the four accused followed him there, and out of the four, three of them Shri Khalil Sheikh, Okil Sheikh in 2016. Thereafter, the dead body was sent to Tura Civil Hospital for post-mortem. The victim is the brother-in-law of the complainant. PW had lodged the FIR on so-and-so at Fulbury, which is so-and-so, identified all the three accused persons. However, he mentioned about seeing one more person who was also involved in the instant case outside the court, whose case has been transferred to JGB, though in the cross he has admitted that the FIR was written by one vendor of Fulbury, and though he does not know the content of the FIR, as he does not know how to read and write, and the vendor did not explain to him. It is seen that the FIR was written on his explanation. After the incident, the police also seized the stick and pestle from the residential compound of Islam Hague, which has been shown by one lady. It is seen that PW1 narration of the incident was substantial and corroborated by the evidence of PW1, PW3, PW2, PW3, and PW, who are the eyewitness to the incident. PW2, Shimati Sulaiman Khatun is one of the eyewitness to the incident. As per the evidence on 12/7/2016 at about 8 a.m. when she looked outside from the kitchen, she saw one person was running, and from behind 3 to 4 persons are following him. He entered the house of one Islam, and one accused Abdul Khalil also entered into the same room. Then the other locked the room. According to her, she rushed to the spot, and some of her friends followed her. From the window of the house, she saw that the victim was being beaten by the accused with a stick used for crushing rice, traditional wooden rice grinder. She also saw the victim was being beaten by two other persons, and since they are just ladies, they just shouted to stop beating the victim, but the accused person did not listen. When they finished beating him, they opened the door and pushed the victim outside the house, where he fell down, and the accused person fled away from the scene. People from locality came to the spot, and they informed the police, and the victim was taken to police station, and thereafter the police took the victim to the hostel. PW2 has identified the accused Abdul Khalil from among the other person in prison when the TIP was held, and she also identified accused Abdul Khalil in the court. She stated that the incident took place at Khalitan. She stated that the accused Abdul Khalil used to visit the house of Islam Hague, where she stayed as a tenant. She reiterated that accused Abdul Khalil and another person whose name she does not know ran after the victim. Though in cross, she admitted that she has not seen the assault by the accused person, as she was standing outside the house and the door was closed from inside. However, it has been confirmed that she saw the accused Abdul Khalil and another person had pursued after the victim. The house owner, Islam Hague, was not present at the time of the incident. She denied the suggestion that no such incident took place in the room. She reaffirmed in re-examination that the incident took place inside the house of Islam Hague, and the place where the incident occurred is known as Khalitan, and she was a tenant at the time in the set compound of Islam Hague. PW3, Shimati and Ajina Bekam is also another eyewitness in the instant case. According to her, on 12/7/2016 at around 8 a.m., she heard some noise from outside, and then she looked outside. She saw Bodil Sheikh was running, and accused Abdul Khalil along with three other persons are following him. The victim Bodil Sheikh entered the house of one Islam Hague, and along with the with the victim, accused Abdul Khalil and his son also entered inside the house and locked the door. When they rushed to the spot to see what is happening, she saw from the window of the house that both the accused person were assaulting the victim body cheek with a wooden stick, which is used for pounding rice. They just shouted from outside to stop beating the victim, but the accused person did not listen. When the accused person finished beating him, they opened the door and pushed the victim outside, where he fell and laid down on the ground outside the house, and the accused person fled away from there. Later on, the public arrived at the spot and shifted the victim to Fulbury CHC for treatment, and later he was referred to higher center, but on the way, the victim expired. PW3 identified the accused Abdul among the other person when TIP was held in prison and identified the accused Abdul Khalil in the court. She also identified the other two accused persons, Abdul Okil and Jahanur Sheikh, in the court. In the cross, she stated that the accused persons are from village Pushni Para. She knows the victim Bodil Sheikh as his father-in-law house is near the house. She reaffirmed that she had seen the accused were running after the victim Bodil Sheikh, and on the day of incident there was nobody in the house of Islam. However, she does not know the reason why the accused person had beaten the victim. PW3 denied the suggestion that she had not seen the assault of the victim by the accused. The victim is not related to PW3, and she came to know of the accused person from the village after the incident. She reaffirmed that incident really took place. The evidence of PW3 has been corroborated by PW4. Shri Jelika Bewa is also another eyewitness. As per her evidence, on 12 July 2016, when she heard the shouting of some people outside the house, she went outside the house and saw that one person was running Bodil Sheikh, and behind him, 3 persons were running after him. The person who was running entered the house of one Islam Sheikh, and the person who were running after him also entered inside the same house, and they locked the door from inside. PW4 heard them beating the deceased, and from the window of the house, she saw that the 2 persons were beating up Bodil Sheikh by a lathi. She shouted at them to stop, but they didn't listen. They assaulted the deceased with a wooden stick used for grinding rice. When they finished beating him, they opened the door and pushed the victim out of the house, and they fled away from the scene. PW4 could recognize the person who assaulted the deceased and identify the accused person who assaulted as Abdul Khalil, Abdul Okil, and Jahanur. Thereafter, the relative of the deceased informed the police the victim was lying in the pool of blood. Till the time the police reached the PO, in cross-examination clarified that the victim Bodil Sheikh is not related to her. She is staying in a rented house that belonged to one Islam Sheikh. She reaffirmed that she has witnessed the incident. The family members were also present at the time of the incident. It is seen that there is a corroboration in the evidence of PW3 and PW4, and even the evidence of PW2 also corroborate with the evidence of PW3 and PW4. PW3 saw Shri Bodil Sheikh was running and accused Abdul Khalil, along with 3 other persons were followed him, which corroborate with the statement of PW4 when she stated that she went outside the house and saw the 1 person was running Bodil Sheikh, and behind him 3 persons were running after him. This also corroborate with the statement of PW2, who stated that she saw 1 person was running, and from behind 3 to 4 persons were following him. PW3 saw the victim Bodil Sheikh enter the house of Islam Sheikh, and along with the victim accused Abdul Khalil and his son also entered inside the house and locked the door, which corroborate with the statement of PW4, who had stated that the person who was running entered the house of Islam Sheikh, and the person who were running after him also entered inside the same house, and they locked the door from inside. When PW3 and the other witnesses rushed to the spot to see what is happening, they saw from the window of the house that both the accused person were beating the victim Bodil Sheikh with a wooden stick, which is used for pounding rice, which also corroborate with the statement of PW4, who had stated that she heard them beating the deceased, and from the window of the house she saw that the 2 persons were beating up Bodil Sheikh by a lathi. PW3 saw from the window of the house that both the accused person Abdul Khalil and his son were beating the victim Bodil Sheikh with a wooden stick, which is used for pounding rice, which corroborate with the statement of PW4, who has stated that they assaulted the deceased with a wooden stick and used for grinding rice. PW3 identified accused Abdul Khalil in TIP and identified the accused Abdul Khalil in the court. She also identified the other two accused persons, Abdul Okil and Jahnur Sheikh, in the court. She affirmed that she has seen the accused person were running after the victim Bodil Hague, and on the day of incident there was nobody in the house of Islam Hague. PW3 affirmed that she has seen the assault of the victim by the accused person. This has been corroborated by the statement of PW4, who has stated that she could recognize the person who assaulted the deceased and identify the accused person who assaulted the deceased as Abdul Khalil Okil, Abdul Okil, and Jahnur Islam. There is a corroboration with the statement of PW2 when she affirmed that she saw the accused person Abdul Khalil and another person chasing the victim, though she admitted that she has not seen the assault by the accused person as she was standing outside the house and the door was closed from inside. Evidence of PW2, PW3, and PW4 stand unshaken even in cross-examination. Therefore, it has been established that 4 persons, the accused herein and another so-and-so, had given the chase and pursued the victim to the house of Islam Hague. PO restrained him there with a common intention to assault and kill the victim. It was established that all the 4 persons, the 3 accused persons herein and 1 so-and-so, were present at the PO while the victim was being assaulted severely with a wooden rice grinding pole which led to his death. Accordingly, the common intention of the 3 accused persons to finish off the victim had been established. PW5, Abdul Monsaf Sheikh confirmed the recovery of the grinding stick. What has been discussed and observed above, the evidence on record has firmly established beyond doubt that Abdul Khalil, Okil, Abdul Okil, and Jahnur Islam, with common intent, has committed murder on the victim as defined under Section 300 IPC read with Section 34. They are also convicted under Section 341 IPC read with Section 34 IPC for wrongful restraint the victim on the house of Islam Hague. They are also convicted under Section 448 IPC read with Section 34 for committing house trespass by forcibly entering the house of Islam Hague to assault the victim. Therefore, the prosecution has been able to prove the kill of the accused beyond reasonable doubt, and as such, this could find the accused person guilty of committing the offence punishable under Section 341, 448, 302/34 IPC. So, Your Lordship, in my humble and respectful submission, Your Lordship, the judgment passed by the learned Session Court, Your Lordship, in convicting the appellant, Your Lordship, is sound and legal, Your Lordship, based on the evidence on record, Your Lordship. So, it needs not be interfered in any manner, Your Lordship. Lordship, then I'll come to the contention of the defense, Your Lordship. The main contention of the defense, Your Lordship, is that there is a delay of lodging the FIR. That is the main contention, Your Lordship. Your Lordship, kindly see, Your Lordship, in this case, Your Lordship. If I take back, Your Lordship, to the FIR, Your Lordship, that is Lordship, the FIR at page 2. Page 2, Your Lordship. The incident took place, Your Lordship, on 12/7/2016 at about 8 a.m. Then, Lordship, if I may read the FIR, Lordship. I beg to at page 2, Your Lordship, that is the type copy. I beg to report you that my brother, Lordship, on 12/7, Your Lordship, yes, was filed on 13, Your Lordship, because first, Lordship, kindly on top, Your Lordship, that there is the date 13 July 2016. On top, Your Lordship, that address to the officer in charge, Fulbari Police Station, West Carhill, Meghalaya, dated 13 July, Your Lordship. Kindly see, Your Lordship, the incident took place on 12/7, Your Lordship. First, they took the victim, Your Lordship, to Fulbari CIC, and then they took him to to Guwahati, Your Lordship, for further treatment, but unfortunately, Your Lordship, on the way he died. Then I'll refer again to the deposition of the informant, Your Lordship, which is at page 19, Your Lordship. Kindly see, Your Lordship, why there is a delay, the delay in lodging the FIR. The delay is not inordinate, Your Lordship. It is only, the delay is under normal circumstances, Your Lordship. Lordship, kindly have page 19. If Lordship, I'll if I take a Lordship somewhere in the middle, Your Lordship, the people gathered there at PO took the victim to the Fulbury police station, and police from there took the victim to the Fulbury hospital, who after administering him first had referred him to Guwahati for better treatment. While taking the victim to Guwahati, but on the way near Holai Danga, he succumbed to his injuries at around 2 p.m. on the same day. That is 12/7. Thereafter, the dead body was brought to Fulbury police station, and police sent it to Pune for repose. Thereafter, received the dead body for the last rite. The victim is my brother-in-law. Then on 13/7, Your Lordship, 13/7/2016, he lodged the FIR, Lordship. This, Your Lordship, this delay is natural, Your Lordship. Certainly, Your Lordship, if my own brother or my own relative, Your Lordship, is assaulted and he suffered injuries, Your Lordship, my duty first is to take to get medical treatment, Your Lordship. So the delay is normal, Your Lordship. And to that, Your Lordship, if Lordship permits me, I'll cite some of the if Lordship kindly have a 2001 7 SCC, page 690, Your Lordship. This is Ravinder Kumar and another Besar state of Punjab. Lordship kindly have a para 13, 14 and 15. May I read it, Your Lordship? Lordship has gotten at paragraph 13, Your Lordship. May I read, Your Lordship? The attack on prosecution cases on the ground of delay in lodging FIR has almost bogged down as a stereotype redundancy in criminal cases. It is a recurring feature in most of the criminal cases that there would be some delay in furnishing the first information report to the police. It has to be remembered that law has not fixed any time for lodging the FIR. Hence, a delayed FIR is not illegal. Of course, a prompt and immediate lodging of the FIR is the ideal, as it would give the person a twin advantage. First, is that afford commencement of the investigation without any time lapse. Second is that expel the opposition of any possible concoction of a false impression. Bearing these two plus points, for a promptly lodge FIR, the merits of the delay cannot operate as fatal to any prosecution case. It cannot be overlooked that even a properly lodged FIR is not an unreserved guarantee of the genuineness of the version incorporated therein. Where there is a criticism on the ground that FIR is in a case was delayed, the court has to look at the reason why there was such a delay. There can be a variety of genuine causes for FIR lodgement to get delayed. Rural people might be ignorant of the need for informing the police of a crime without any lapse of time. This kind of unconverted sadness is not too uncommon among urban people also. They might not immediately think of going to the police station. Another is due to lack of adequate transport facilities for the informers to reach the police. The third one is quite in common, is that the kin and kin of the deceased might take some appreciable time to regain a certain level of tranquility of mind or sedativeness of temper for moving to the police for the purpose of furnishing the requisite information. Yet, another cause is the person who are supposed to keep such information themselves could not be physically impaired, that the police had to reach them on getting some nebulous information about the incident. We are not providing an exhaustive catalogue of instances which could cause the delay in lodging the FIR. Our effort is to try to point out that the still demand made in the criminal code to treat the FIR be sheeted merely on the ground of delay in its lodgement cannot be approved as a legal corollary. In any case, where there is a delay in making, the court has to look at the causes for it, and if such causes are not attributed to an effort to concoct a version, no consequence shall be attributed to the mere delay in lodging the FIR. By so and so, the court made the following observation. It is well settled that the delay in keeping the by itself cannot be a ground to doubt the prosecution case. Knowing the Indian condition as they are, we cannot expect these billiards to rush to the police station immediately after the occurrence. Human nature as it is, the kin and kins who have witnessed the occurrence cannot be expected to act mechanically with all promptitude in giving the report to the police. At time being griefs taken because of the calamity, it may not immediately occur due to them at that and they should keep a report. After all, it is but natural in these circumstances for them to take some time to go to the police station for giving the report. Here, Your Lordship, the delay as I have submitted, Your Lordship, first took the victim, Your Lordship, to the hostel, then to Kawati, but on the way, unfortunately, he succumbed to the injuries and died, Your Lordship. Then on the very next day, the FIR is lodged, Your Lord. Then, Lordship, another decision, if Lordship kindly have a 2015 1 SEC, page 737, this is Dilawar Singh and others. On delay, Your Lordship, yes. 2015 1 SEC, page 737, Your Lordship. Dilawar Singh and other versus State of Haryana. Lordship kindly have a para 22. Lordship, this is a fit exactly with the present case, Your Lordship. Lordship kindly have a paragraph 22. Whether the delay, Lordship has gotten. Whether the delay is so long as to draw a cloud of suspicion on the prosecution case will depend on variety of factors, which will vary from case to case. As pointed out by the learned court from the very beginning, the condition of injured Narinder Singh was very serious, exactly, Your Lordship, here in the case. And he was struggling for assistance, and his father, PW6, and uncle, Hukum Singh, were concerned about the welfare of the injured. While so, they could not have thought of approaching the police first and informing them about the incident. Where the delay in lodging of complaint and registration of FI has been satisfactorily explained, the delay by itself is no ground for disbelieving the prosecution evident party where it has been accepted both by the High Court. Coming to the further contention of the appellant raising doubt about the credibility of Peter or not making the statement at least to is so and so on receipt of the information regarding commission of injury, so and so went to PGI hostel to record the statement. And at that time, Chandra Singh was attending to his son. The contention of the appellant is that had the occasion to inform the police about this at least to so and so, but the same has not. We raise a serious doubt about the presence of Chandra Singh, PW6, at the scene of one. By perusal of the evidence of PW4, it is seen that on receipt of intimation from so and so, PW4 rushed to the hostel for recording the statement of the injured Narinder Singh. Since Chandra Singh did not offer any statement to ASI Karan, since Narinder Singh was then alive, there was no occasion for recording the statement. It also brought in evidence that after the death of did not go to the for the same time. In our view, there is no merit in the submission that is to be disbelieved on the ground that he did not choose to keep any statement, at least to ASI so and so. Then para 30 of 24, Your Lordship. Narinder Singh died at so and so on so and so, and thereafter Chandra so went to on so and so at so and so and lodged the complaint was registered at subsequent of event clearly showed that PWC was attending to his son and was taking steps to shift injured from Community Health Center Ladwa to Lok Nayak Jaipur Hospital and from Kurukshetra to PGI Chandika, and PWC was busy in urging for morning medical. The delay of about 15 hours and 15 minutes in lodging Deva in our view cannot be said to be fatal. The Learned Court have recorded concurrent finding that the delay in registration of error has been satisfactorily explained and the delay is not fatal to the prosecution. So, Your Lordship, this decision rule for the reason that hardly one comes across a witness whose evidence does not contain a grain of untruth or at any rate exaggeration, embroideries or embellishment. In most cases, the witness, when asked about detail, venture to keep some answer not necessarily true or relevant for fear that their evidence may not be accepted in respect of the main incident which they have witnessed, but that is not to say that their evidence as to the salient feature of the case after cautious scrutiny cannot be considered. Then, Lordship, I'm coming back to another case, Your Lordship, that is 1983 3 SEC page 217, Your Lordship. Lordship, that has been referred, Your Lordship, just at paragraph 5, Your Lordship. Paragraph 5. Paragraph 5, Your Lordship, and then Lordship kindly have internal page 222, Your Lordship. If Lordship kindly have page 222, Your Lordship, the reasons are obvious. Down below, Your Lordship, 1, 2, Your Lordship, then the sentence reads, the reasons are obvious. Lordship has got in. Lordship kindly have page 222, Your Lordship. Lordship kindly have below, Your Lordship, over much importance cannot be attached to minor discrepancies. The reasons are obvious. Lordship has got that. Lordship 1 and 2. By and large, a witness cannot be expected to possess a photographic memory and to recall the detail of an incident. It is not as if a videotape is replayed on a mental screen. Ordinarily, it so happened that a witness is overtaken by events the witness could not have anticipated, the occurrence which are so often has an element of surprise. The mental faculties therefore cannot be expected to be attuned to absorb the detail. The power of observation differs from person to person. What one may notice, another may not. An object or movement might emboss its image on one person's mind, whereas it might be go unnoticed on the part of another. By and large, people cannot accurately recall a conversation and reproduce the very words used by them or heard by them. They can only recall the main purport of the conversation. It is unrealistic to expect a witness to be a human tape recorder. In regard to exact time of the incident, the time duration of an occurrence, usually people make their estimate by guesswork on the spur of the moment at the time of the interrogation, and one cannot expect people to make very precise or reliable estimate in such matters. Again, it depends on the time scene of individual, which varies from person to person. Ordinarily, a witness cannot be expected to recall accurately the sequence of events which take place in rapid succession or in a short time span. A witness is liable to get confused or mixed up with interrogated later on. A witness, though wholly untruthful, is liable to be overawed by the court atmosphere and the piercing cross-examination made by the counsel, and out of the nervousness mix up facts, gets confused regarding sequence of event, or fill up details from imagination on the spur of the moment. The subconscious mind of the witness sometimes so operate on account of the fear of looking foolish or being disbelieved, though the witness is giving a truthful and honest account of the occurrence witnessed by him. Perhaps it is a sort of a psychological defense mechanism activated on the spur of the moment. Then Lordship kindly have 1999 SCC 649, page 649. (1999) 8 SCC 649, Your Lordship. Lordship kindly have paragraph 24, 25, 26. Lordship kindly have paragraph 24. When an eyewitness is examined at length, it is quite possible for him to make some discrepancies. No true witness can possibly escape from making some discrepant details. Perhaps an unique witness who is well tutored can successfully make his testimony totally non-discrepant. But court should bear in mind that it is only when discrepancies in the evidence of a witness are so incompatible with the credibility of his version that the court is justified in jettisoning his evidence. But too serious a view to be adopted on mere variation falling in the narration of an incident, either as between the evidence of two witnesses or as between two statements of the same witness, is unrealistic approach for judicial scrutiny. It is a common practice in trial court to make contradiction from the very statement of a witness for confronting him during cross-examination, merely because there is inconsistency in evidence. It is not sufficient to impair the credit of the witness. No doubt, Section 155 of the Evidence Act provides scope for impeaching the credit of a witness by proof of an inconsistent formal statement, but a reading of the section would indicate that all inconsistent statements are not sufficient to impeach the credit of the witness. The material portion of the section is extracted. Then para 26, Your Lordship. A formal statement, though seemingly inconsistent with the evidence, need not necessarily be sufficient to amount to contradiction. Only of the inconsistent statement which is liable to be contradicted, which would affect the credit of the witness. Section 145 of the Indian Evidence Act also enables the cross-examiner to use any formal statement of the witness, but it cautions that it is intended to contradict the witness. To cross-examiner is enjoined to comply with the formality prescribed. Section 162 of the Code also permit the cross-examiner to use the previous statement of the witness recorded under Section 161 for the only limited purpose, that is to contradict the witness. Then Lordship kindly have another decision, that is 1999-9, Your Lordship, SCC. SCC, page 525, Your Lordship. Lilaram versus State of Haryana. Lordship kindly have para 9. Be it noted that the High Court is within its jurisdiction, being the first appellate court to reappreciate the evidence. Lordship has gotten para 9, Lordship. But the discrepancies found in the occult amount of two witnesses, unless they are so vital, cannot affect the credibility of the witness, the evidence of the witnesses. There are bound to be some discrepancies between the narration of different witnesses, even when they speak on detail, and unless the contradiction is of a material dimension, the same should not be used to jettison the evidence in its entirety. Incidentally, corroboration of evidence with mathematical niceties cannot be expected in criminal cases. Minor embellishment there may be, but variation by reason thereof should not render the evidence of eyewitness unbelievable. Trivial discrepancies ought not to obliterate an otherwise acceptable evidence. In this context, reference may be made to the decision of this court in state so and so versus so and so. While appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appear to have a ring of truth. Once that impression is formed, it is undoubtedly necessary for the court to scrutinize the evidence more particularly, keeping in view the deficiencies, drawbacks, and infirmities pointed out in the evidence of the whole, and evaluate them to find out whether it is against the general tenor of the evidence given by the witness, and whether the earlier evaluation of the evidence is shaken so as to render it unworthy of belief. Minor discrepancies on trivial matters not touching the core of the case, hyper-technical approach by taking sentences out of tone of context here and there from evidence attaching importance to some technical error committed by the investigating officer, not going to the root of the matter, would not only permits rejection of the evidence as a whole. If the court before whom the witness give evidence had the opportunity to form the opinion about the general tenor of the evidence given by the witness, the appellate court, which had not this benefit, will have to attract due weight to the evidence of the evidence by the trial court, and unless they are reason weighty and formidable, it would not be proper to reject the evidence of on the ground of minor variation or infirmities in the matter of trivial detail. Even honest and truthful witness may differ in some detail unrelated to the main incident because power of submission, intention, differ from with individuals. In a very recent decision, Ramni versus State of UP, when an eyewitness is examined at length, it is quite possible for him to make some discrepancies. No true witness can possibly escape from making some discrepancies. Perhaps an untrue witness who is well tutored can successfully make the testimony totally non-discrepant. But court should bear in mind that it is only when the discrepancies in the evidence of the witness are so incompatible with the credibility of the version that the court is justified in jettisoning his evidence. But too serious a view to be adopted on mere variation, falling into the narration of the incident, either as between the evidence of two witnesses, as between two statements by the same witness, is an unrealistic approach for judicial scrutiny. Then, Lordship, if Lordship, I come back, Your Lordship, to that Allahabad judgment, Your Lordship. That is 2019 SEC Online 5864, Your Lordship. Kindly have again, Lordship, that judgment. Why I'm citing, Your Lordship, this part of the judgment, Your Lordship, because there are two eyewitnesses, Your Lordship. The one which I had read earlier, Your Lordship. The one which I had read earlier, Your Lordship. So far, the delay of lodging the FIR from page 49 to 53, Your Lordship. Now I'm coming, Your Lordship, to the quality of evidence, Your Lordship. Lordship, kindly have a para 37 of that judgment. Para 37, Your Lordship. May I read it, Your Lordship? Law is well settled that as a general rule, court can and may act on the testimony of a single witness, provided he or she is wholly reliable. There is no legal impediment in convicting a person on the sole testimony of a single witness. That is the logic of section 134 of the Act. That is the Indian Evidence Act. But if there are doubt about the testimony, court will insist on corroboration. In fact, it is not the number, the quantity, but the quality that is material. Time-honored principle is that evidence has to be weighed and not counted. Test is to whether evidence has a ring of truth, cogent, credible, trustworthy, or otherwise. 38, Your Lordship, para 38. Court reiterated the view observing that it is the quality and not the quantity of evidence which is material. Quantity of evidence was never considered to be a test for deciding the criminal trial, and emphasis of court is always on quality of evidence. The legal system has laid emphasis on value, weight, and quality of the evidence rather than on quantity, multiplicity, or plurality of witnesses. It is therefore open to the competent court to fully and completely rely on the solitary witness and record conviction. Conversely, it may acquit the accused in spite of testimony of several witnesses if it is not satisfied about the quality of the evidence. Lordship, then para 940, Lordship, this is the reiteration of what has been said earlier, Your Lordship. Lordship, why I'm setting this judgment, Your Lordship, because in the case, Your Lordship, there were two eyewitnesses, Lordship. Two eyewitnesses, Lordship. The only part, Your Lordship, is that the TIP, Your Lordship. The TIP, Your Lordship, I would fully submit, Your Lordship, that it was conducted, Your Lordship, in the present, the police, the IU also, he was present, Your Lordship. So it may not be admissible, Your Lordship. Lordship, but beside that, be that is as it may, Your Lordship, minus the TIP, Your Lordship, there are evidence on record, Your Lordship, about the involvement of the appellant in this case, Your Lordship, because the two eyewitnesses, Your Lordship, they have clearly stated in their evidence, Your Lordship. They have strictly stated in their eyewitness, Your Lordship, and that part of the evidence, Your Lordship, has not been demolished or shaken during the course of cross-examination. So that evidence of those two eyewitnesses remain, Your Lordship. To conclude, Your Lordship, my humble and respectful submission, Your Lordship, the finding of the learned court below, Your Lordship, are sound and justified, Your Lordship, in convicting the appellant under the relevant section of the Indian Penal Code, Your Lordship. Lordship, another condition also, sorry, Your Lordship, I forgot, Your Lordship, that is, Your Lordship, regarding the absence of forensic report, Your Lordship. Lordship, in that, Your Lordship, I'm citing a judgment, Your Lordship. I'm relying on the judgment, Your Lordship, that is 2024 SCC Online, Jharkhand, Your Lordship, 1646. Lordship, kindly have para 20 of that judgment. Lordship, may I read it, Your Lordship? The learned counsel for the appellant also argued that the dagger which was recovered was not sent to FSL for examination. This defect in investigation is not found fatal to the prosecution case because the prosecution case is based on direct evidence. In case of a direct evidence, then, Lordship, another decision, Your Lordship, that this is 2012, Your Lordship. 2012, 4 SCC, page 559, Your Lordship. Promote Day versus State of West Bengal. Lordship, kindly have para 2021 of that judgment. Lordship has got it. Similarly, we do not find any merit in the contention of the learned counsel for the appellant that PW so and so do not support the prosecution case and that the FSL report was not collected from the forensic laboratory if the kill of the appellant is established beyond reasonable doubt through the evidence of PW so and so. We cannot also draw any adverse inference from the fact that the granduncle of Manika was not examined, as he was neither the nor the and was not in fact in the same house where the incident occurred, as would be clear from it. In our opinion, the High Court is right in sustaining the conviction of the appellant on the basis of the eyewitness account of PW2 and evidence of PW1, PW8, and PW, as well as the recovery of the dowry at the instant of the appellant. The impugned judgment of the High Court is therefore sustained and appeal is dismissed. Then, Lordship, another decision, Your Lordship, which I would like to rely, Lordship, on Section 34 of the Indian Penal Code, that is 2010 SCC, page 407, Your Lordship. 2010 SCC, page 407, Your Lordship. Lordship, kindly have paragraph 42, Your Lordship. Section 34 of page 4, para 42, Your Lordship, at page internal page 421. Section 34 IPC does not create any distinct offence, but it lays down the principle of constructive liability. Section 34 IPC stipulates that the act must have been done in furtherance of the common intent. In order to incur joint liability of an offence, there must be prearranged and premeditated concert between the accused for doing the act actually done, though there might not be a long interval between the act and the premeditation, and though the plan may have formed suddenly. In order that Section 34 may apply, it is not necessary that the prosecution must prove that the act was done by a particular or specified person. In fact, the section is meant to cover a case where a number of persons act together, and on the fact of the case, it is not possible for the prosecution to prove as to which of the persons who acted together actually committed the crime. Little or no distinction exists between the charge for an offence under a particular section and the charge under section read with Section 34. Then, Lordship, another decision, Your Lordship, this is 2004 11 SCC, page 305. Of 305, Your Lordship. Lordship, kindly have paragraph 12 and 13. Lordship, kindly have a paragraph 12, Your Lordship, at page 314, internal page 314. To appreciate the argument advanced on behalf of the appellant, it is necessary to understand the objective in incorporating Section 34 in the Indian Penal Code. As a general principle, in a case of criminal liability, it is the primary responsibility of the person who actually commit the offence, and only that person who has committed the offence can be held guilty. By introducing Section 34 in the Indian Penal Code, the legislation laid down the principle of joint liability in doing a criminal act. The essence of that liability is to be found in the existence of a common intention connecting the accused, leading to the doing of a criminal act in furtherance of such intention. Thus, if the act is the result of a common intention, then every person who did the criminal act with that common intention would be responsible for the offence committed, irrespective of the share which he had in its perpetration. Section 34 embodies the principle of joint liability in doing the criminal act based on a common intention. Common intention itself being a state of mind, it is very difficult to procure direct evidence to prove such intention. Therefore, in most cases, it has to be inferred from the act, the conduct of the accused, or other relevant circumstances of the case. The inference can be gathered from the manner in which the accused arrived at the scene and mounted the attack, the determination and concert with which the attack was made, and from the nature of injury caused by one or some of them. The contributory act of the person who are not responsible for the injury can further be inferred from the subsequent conduct after the attack. In this regard, even an illegal omission on the part of such accused can indicate the sharing of common intention. In other words, the totality of circumstances must be taken into consideration in arriving at the conclusion whether the accused had the common intention to commit an offence on which they could be convicted. Lordship, with this two citations, I am conclude my argument, Your Lordship. Highly obliged, Your Lordship.
Lordship will file our written submission. We will file our written submission. No, we will file, Lordship. We will file, incorporating all the.
Lordship. It's, I'm just doing my
one pertinent issue, that
my
TIP.
job, you know.
That TIP. Yes.
That I have submitted, Lordship. Minus TRP, there are enough
And
evidence.
eyewitnesses.
There were two eyewitnesses.
Lordship, if you go by the statement of the eyewitness, they are not eyewitnesses. They are also the hearsay. We'll incorporate all those things in the details.
Two weeks, Your Lordship.
Item number 15. Any mention?
Wait, please, Your Lordship. Lordship, I beg to make a mention of item number 16, Lordship. Joint request, Your Lordship, this matter.
After 1 week, Lordship. A joint request, Lordship. Yes, Lordship, we have not started with the, only received the paper book. Just after 1 week.
Lordship, highly obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 21. The learned conducting counsel is in bereavement, Your Lordship. Therefore, I humbly pray Your Lordship may be pleased to fix this matter after 3 weeks.
No objection, Your Lordship.
Learned conducting counsel, Mr. Sandeep Jindal. His son passed away. Yes, Your Lordship. Yesterday, sir. Yes. Before he was in admits, later on he was shifted to Assam Valley yesterday, sir. Yes, sir. I also beg to mention item number 22, Your Lordship. Similar prayer, Your Lordship. 3 weeks. Much obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 26. I'm praying for 2 weeks of time, Your Lordship.
Lordship, I'm appearing for respondent number 3 and 4, cantonment. Obliged,
Most obliged.
May it please Your Lordship, I beg to mention item number 19, Your Lordship. I'm representing on behalf of Mr. P.R. Paskia for the respondent number 3 and 4. Two weeks, Your Lordship. Nice.
May it please Your Lordship. Your Lordship, I beg to mention item number 20. Lordship, Dr. Mozika is on leave, Your Lordship. I'm praying for 2 weeks' time in this matter, Your Lordship. No objection, Your Lordship. Much obliged. May it please Your Lordship. Your Lordship, I beg to mention item number 31. Your Lordship, on the last date, Mr. Sen had made his submissions, and we had stated that we'll compile some judgments, Your Lordship. So we are still preparing the compilation.
Lordship? I have not started. They have to continue, Lordship. Yeah. No objections, Lordship.
Obliged, Your Lordship.
Grateful.
My Lord, I also beg to mention item number 15. Needs an accommodation for just a week, my Lord. This was actually, we have started argument also. Item number 15, my Lord. These are those district selection matters from the Garo Hills, my Lord, where I've started also argument. But I just lost track of the case, my Lord. Just a week's time, my Lord. I will finish it on the next day. 1 week, my Lord.
Your Lordship, I also beg to mention item number 18, Your Lordship. No objection, Your Lordship. 2 weeks, Your Lordship.
I beg to mention item 28, Your Lordship. 28. No objection, Your Lordship.
2 weeks time, Your Lordship. Much obliged, Your Lordship.
May please, Your Lordship. Lordship, I beg to mention
28, 27, 28.
28, Your Lordship, I'm mentioning. Sir, you want to see 28.
These are all connected, Lordship.
All connected.
This is all connected. No, Your Lordship.
This is connecting with her, Your Lordship.
I'm there for 27, 29,
And 30.
24th, Your Lordship. I'm begging for 2 weeks time.
We have no objection on this matter.
It'll come out after 2 weeks, Your Lordship.
Obliged. Yes. My lord, 27, 28, 29 and 30, these are all connected. This is, they have challenged the appointment of the private respondent, Lordship. 27 to 30, Lordship.
30, Your Lordship. I'm for 28, Your Lordship. She's for 27, 29 and 30. I've already mentioned, Your Lordship.
20.
27 to 30.
Yes. 27, 28, 29, 30. These are connected, Your Lordship.
But on the last occasion, it was taken separately, Your Lordship. Because on some urgency, this matter was taken up separately.
Let it be together, Your Lordship. Issue is same, Your Lordship.
Division is also same. Category division.
How long was this 28?
2 weeks, Your Lordship.
2 weeks?
Lordship, yes. Oblige, Your Lordship.
May please, Your Lordship, I beg to mention item number 23. I'm praying for 2 weeks time.
No objection, Your Lordship.
My lord, I beg to mention item number 34. I'm praying for 2 weeks time. Which item? 34. Apply, Lordship.
Please, Your Lordship. Item number 17. Like to mention after 2 weeks, Lordship. For District Council. I don't know. Yes.
17.
70. 70. I come after 2 weeks. 70.
Your Lordship, I'm appearing for respondent number 7.
I'm for 4 to 4 and 5.
Newly impleted. Newly impleted is 7.
Okay.
Right, Lordship.
In daily list, item number 1. Hello, this is a criminal appeal against the judgment and order dated 6/12/2024.
May be admitted, Lordship.
My lord.
Conviction.
My lord, conviction 5 years now. Legally. Item number 2.
Your Lordship, we require some more time to file our affidavit, Your Lordship. You are rejoinder, Your Lordship.
Yeah, Lordship, counter effect.
Taking too long. Only in this way we are just going round and round.
Yes, Lordship. Lordship, 2 weeks, Your Lordship.
The date will be. Lordship, after 2 weeks, 15th.
Okay, Your Lordship.
Item number 2 and 3.
2 and 3.
2 and 3.
Item number 4.
Oblige.
Item number 4.
Paper book.
May I please, Your Lordship. Lordship, in this case, I have just received half of the brief, the records. So, if I may pray for calling the lower court's records so that I could prepare the paper book, Lordship. Then I pray for 2 weeks' time, then, Lordship, I'll prepare the paper books. Deeply obliged.
Much obliged, Lordship.
Item number 5.
Your Lordship, I'm appearing on behalf of S.R. Lingdor for the respondent number 4 to 12. We have received a copy of rejoinder of affidavit from the petitioner.
May I please, Your Lordship. The rejoinders for the respective parties have been duly filed and copies have been supplied to the respondents. Yes, Your Lordship, matter may be posted.
Your Lordship, with the leave of the court, can you grant us 3 weeks to kindly look into the affidavit? We can to advance argument accordingly, or to file a reply to the rejoinder. 3 weeks. That's as per the instruction given to me by my learned senior.
And for respondent 1 to 3.
Highly obliged, Your Lordship.
Item number 6.
You have 2 copies, only one. Only one.
Yes, Lordship, I am for the petitioner.
We have received the updated status, my lord, and the claims of the plea of alibi will not arise over here, my lord. We have a very detailed status report over here.
Lordship, this is
not. Doctor who has whom you have visited is a woman doctor. He doesn't run a punishment. Prescription was option blood option format, which is usually not issued by doctor even in a private medical.
But he has the clinic, Lordship. He has gone to his own clinic only. And there is prima facie that he has gone there and he was attending to his. Yes, Lordship. He is running his own clinic in Nangba only, Lordship. There only because the petitioner, his wife stays there in Nangba itself. And the hospital also is not far. So he was staying there with along with his wife. So that it could be easier for him to attend to his ailing mother. So thereby then when he had this.
Doctor doesn't have a clinic.
There is very much, Lordship. And Lordship,
My lord, even at their application, Lordship, at page 5, Lordship. Paragraph 5, my lord, page 4. If I may read, my lord. Yes. Paragraph 5. That the petitioner begs to submit that while attending to his mother at the hospital, the petitioner himself had consulted a doctor for his personal treatment on so-and-so date. The medical prescription issued to him serves as documentary evidence of his presence at the hospital, Lordship. Whereas from the statement of the doctor, he was nowhere near the hospital when without a letterhead, that Kacha note was given. Hence, the attending doctor is also competent to testify this fact, which is already done so, my lord, thereby corroborating the petitioner's alibi and establishing that he was at the said hospital, which is in fact far away from the place of occurrence. Paragraph 6. That the petitioner begs to state that his name has been randomly mentioned in the said FIR, dated so-and-so, with an ulterior motive without any cogent or credible evidence of his presence at the alleged place of occurrence on the said date of incident. The FIR is thus vitiated by malified motives and the petitioner's established alibi of being present at Woodland Hospital, my lord. He was not at Woodland Hospital, my lord, because as has been pointed out at the status report, the doctor who had issued the, without the letterhead, that note, lordship, is a government doctor. He's not employed in Woodland.
Lordship, that may be the typical mistake, but the thing is that I have already annexed my prescription. This is because he was also attending at the same time and he was treated there. That is the only fact which remains, Lordship. It is not that due to the typical mistake, on top of the fact already have been stated that he has consulted the doctor while attending to his ailing mother who was hospitalized. So after he has taken, when he was all right, he could have attended also. Maybe that it was the only mistake in typing. And Lordship, he's here. The thing is that Lordship, the main is that he has got a standing in the society. Lordship, he's a teacher, assistant teacher in the upper primary SSA school in Lakadong itself. He's not from anywhere.
My lord?
Not yet, Lordship, not yet.
No, my lord.
Residents of both villages have gathered at the same place of inspection. said some persons, some of those present have assorted to writing and use of firearms and ultimately open fire on gathering, as a result of which 3 villages of Archival were seriously injured. Yes, on receipt of such information, the fire was fired. And a case registered here.
Yes, Lordship.
Not present when the second incident happened. Since on the second day, that is Q3, he was attending and also on the second day, he had also running who was where did you say that you have
Clinic in Nangba.
They just said hospital, Lordship. At paragraph 5, the medical prescription issued to him serves as documentary evidence of his presence at the hospital.
He has prescribed the prescription in his private capacity, Lordship. Nangba, Lordship.
your government where we stated that you had visited the doctor at his clinic at Lomba.
It's not there, my lord. At paragraph 6 also, 5 and 6, and the petitioners establish alibi of being present at the Woodland WK Hospital.
In paragraph number 4, Lordship, although I have not mentioned Nangba, this is that the petitioner had been, paragraph 4, Lordship, had been staying with his wife and children at Nangba village, nearby Nangba. Nearby Nangba only, Lordship.
For his personal statement, for which medical prescription was issued same next year. In this petition, page 16. As such, petitioner not being present although his name was said, although he was said allegation that there are some witnesses who had seen him at the place of occurrence is not correct. It is doctor exception that because of the fact that his name was the fact that he was said to be involved in the said incident, therefore police are on the lookout. Hence, the appraisal of the offence. It is the conception that this is a good reason with slow suicidal standing if arrested to proceed would suffer and would suffer equal of prejudice. If based on this, this is the abide by the this court will step up it and maybe you had appeared before the IO.
Yes, Lordship. Twice he has already appeared.
This also something that petitioner on making bail being granted according to the school. Common as likely appeared before the IO. Also, the statement was recorded.
Yes, Lordship.
as per additional feature, would confirm that this pre-authorized cannot suspend in as much as on being registered to the detailed file on this aspect. File status report wherein it has been stated that live listed said doctor who has allegedly treated the petitioner and said to have issued said medical prescription. However, as follows, and said the doctor, that is Dr. W. who does not run any private clinic at law, since he is presently posted as in charge of Namba Primary Health Center, West, which is considerably distant from Goa. This doctor has, however, stated that though he could not clearly recollect the exact date, but he did mention that one morning, petitioner had come to the official quarters of PHC. Now, PHC, website is complaining of common illness, and accordingly, he prescribed medicine. This is the case, and given severely and severely claim of petitioner is compounded and judicial and case false information given by him. On the facts stated here above, it's need to understand that the incident has taken place on Q3 wherein there was some altercation and some person is also from the material report. Is also noted that some of the evidence who were present at the prison, correct? Even if they didn't take place, and I feel that some of them who are present in the same gathering and who are also responsible for one such view. This court of Procedural offence committed by section of law are serious nature, one of which involves death for the punishment of which would be likely to be but it is also contrary to law that the investigation is still ongoing and judgment has not been made. The proposal of the status report by the proposal by the same has mentioned the fact that the step doctor does not run any private clinic after why. This fact was also affirmed by the head counsel for the prisoner, who has countered by stating that clinic run by the step doctor is actually situated at the Lamba place, which is some distance from the bar. The fact that the said doctor has also acknowledged having examined or rather treated the patient at his option quarters, that is that Alba has also been noted under such circumstances. court would not be able to sue either upon or discard of whether the key of the life is recorded or not. It will be eventually a matter of evidence. Right. Since listener has already made his opinion or proceed by and considering that his teacher by profession, having outstanding society, upon to the fact that there is fixed apprehension of the same findings of the investigation at this point in time, court is like allow no condition.
Obliged, Lordship.
Should I enter this?
My lord? Lordship.
Is this a copy or this is?
It's an extract copy, my lord, but I'll need it for the next two cases also, my lord.
Item number 7.
May I please, your lordship? Lordship, we have an updated status report. The report is clear over here, my lord. Arising from the same FIR, lordship. Same FIR.
This also alibi.
Yes, your lordship.
My lord, but it's otherwise, my lord, the report says. So as the report says, my lord, I have to give a fair submission. This will be for items 7 and 8, my lord, arising from the same FIR, lordship. Lordship.
Report of private 2 million. Let's say private line, which is brought on record. Why not? That's very selected there. Report of value will confirm that the petitioner was in lodged at Prosecuted and Procedural on the same day. From 1/3/2026 to 4/3/2026. As such, imputed and raising of the fees of the on the this basis of such report, discussing the report of this
Much obliged, Lordship.
Much obliged, Your Lordship.
Item number 9.
Wait, please, Your Lordship. Lordship, this matter needs physical hearing, Your Lordship. Due to some personal difficulties, Lordship. Lordship. Lordship, Senior Counsel Mr. Paul is not available today, Your Lordship. Tuesday, Lordship. Highly obliged, Lordship.
Much obliged, Lordship.
This is for 9, 10 and
9 and 10. 9 and 10, my lord.
Connected.
Much obliged, Lordship.
Item number 11.
Lordship, in this matter, we are yet to file the affidavit. We need 2 weeks' time, Your Lordship.
No objection, Your Lordship.
Apply, Your Lordship.
Item number 13.
My lord, this is the minutes of the meeting, my lord. The settlement has been arrived at. So, my lord will come to the second page. So, my lord, these I need to bring by way of an affidavit, my lord. I've served a copy of this to the. Well, this is the minutes of meeting. This is the minutes of meeting dated 30/3/2026. My lord, kindly give me 2 weeks, my lord. Obliged.
Item number 25.
May it please your lordship. Lordship, from 4/9/25, Lordship, notice has been issued to the writ petitioner after the withdrawal of the earlier counsel. Today also, Your Lordship, it appears that notice has been served, but say fine. 10, Your Lordship, yes.
There is a report by the post office.
I don't know.
It says it has been delivered.
Delivered, Your Lordship.
Except Constitution number 7, which is far no return. No such person in the address.
But Lordship, the petitioner number 1 is the lead petitioner, Your Lordship.
Yes, of course.
It's the lead petition.
You can throw some light on the status of exporter.
If Lordship kindly have page 6 at paragraph 3, it appears that this is a unregistered organization by the name of Kabri Uhnyuk Tribe Exporter and Importer Association. Kindly have page 6 at paragraph 3, Your Lordship. So appears, Your Lordship, that they are all members of this association only.
Except for one petitioner, that is which is the program. Since this has been mediated, petitioner not being present, this matter is posted to the allow
Apply, Your Lordship.
Item number 32.
This criminal appeal, Lordship. Mr. Carlingdo is there. It may be taken up another date, Lordship, since he's absent. Another date.
KV Khalindo, do not mark him absent, my lord. I'll just seek. My lord.
2 weeks.
My lord.
Item number 33.
My lord, this is a challenge to an